Rule 2 of the Judicature Criminal Procedure Application Rules SI-30-8, which provided that criminal applications before the High Court shall usually be in writing. In reply, counsel for the defense submitted that that piece of legislation is admissible since Rule 48, since Section 48 of the Judicature Act, under which it was enacted, was repealed, and no similar text exists in the revised Judicature Act Cap 16, which is now applicable law. He added that oral application would save less time, as it is in the interest of justice. He added that oral application will save court's time, as it is in the interest of justice for the accused person to follow witnesses who had recently reached out and stated that they have evidence which may be beneficial to our case. The defense further argued that Article 28(1) guarantees the accused person the right to a fair hearing, which is augmented by Article 44 of the Constitution, which states that the right to a fair hearing is non-derogable. It was the position of the defense counsel that Article 136(2) of the Constitution is clear that substantive justice should be administered without undue regard to technicalities. We pray that court allows the defense to make the application to present the two witnesses and disclose the evidence for determination. Pre-trial disclosure is a cardinal principle of criminal justice. This is to ensure fairness and avoid trial by ambush. The principle applies in equal force to both the prosecution and the accused. I wish to distinguish the ruling referred to, where this court held that disclosure is an ongoing process and permitted the prosecution to disclose evidence to the bar, evidence to the defense at the bar during cross-examination from the circumstances of the current application. AW1, the accused person, gave evidence in chief on the basis of which the prosecution discovered evidence to aid in its cross-examination and sought to disclose the same to the defense at about. The ruling on disclosure being an ongoing duty is therefore relating to evidence or matters that are discovered during the pendency of the trial, not matters that are not new or reasonably have been anticipated. That is the context in which the ruling on continuous disclosure was made. In the instant scenario, before the conclusion of the re-examination of the defense sought to make another application to disclose two additional against witnesses and their evidence. Section 76 of the Trial Indictments Act, Cap 25, restricts an accused person's right to call witnesses not disclosed between the trial and provides as follows. An accused person shall be allowed to examine any witness if the witness is in attendance, but he or she shall not be entitled as of right to have any witness summoned other than the witnesses whom he or she named to the magistrate's court committing him or her for trial as witnesses when he or she desired to be summoned. This implies that an accused person who wishes to disclose new witnesses and evidence during the trial can do so with leave of court. Whereas counsel for the defense argued that this leave can be sought orally, the prosecution objected to this mode and relied on Rule 2 of the Judicature Criminal Procedure Application Rules, SI-13-8, which provided that applications of that nature shall usually be in writing. Counsel for the defense submitted that the revision of the Judicature Act of December 2023 repealed Section 48(1)D, on which the Judicature Criminal Procedure Application Rules was anchored, and therefore that the said statutory instrument is no longer applicable and cannot feature in this matter. The reenactment of the Judicature Act resulted in the provision on which SI 13.8 was anchored being excluded from the revised edition. Black's Law Dictionary, the 12th edition, defines reenactment to mean a legislature passing a statute again for some purpose, such as codification in substantially the same form as it has been in effect. The revisions of the laws of 2023 resulting in changes to the Judicature Act was conducted under the Law Revision Act, Act 3. Section 12 of the Interpretation Act provides that where any act or part of an act is repealed and reenacted with or without modification, statutory instruments made under it shall, unless a contrary intention appears, remain in force so far as they are inconsistent with the repealing act until they have been revoked or repealed by statutory instruments made under the repealing act, and until that revocation or repeal shall be deemed to have been made under the repealing act. I have perused the Judicature Act Cap 16. There has been renumbering of the provisions which appeared in the Judicature Act Cap 13, but no equivalent of Section 48 of the Judicature Act Cap 13, under which the Judicature Criminal Procedure Application Rules were anchored, is in the new Judicature Act. The old Judicature Act Cap 13 does not conflict with the reenacted Judicature Act Cap 16 in as far as the statutory instrument is concerned. It is my view, therefore, that repeal of Section 48 of the Judicature Act Cap 13 by the reenactment of Judicature Act Cap 16 does not affect the application of the statutory instrument, which provides that all applications to the High Court in criminal cases shall usually be in writing, and where evidence is necessary, be supported by evidence. In seeking to make the oral application, the defense argued that the right to fair hearing guaranteed to an accused person under Article 28(3)(1) is non-derogable by operation of Article 44 of the Constitution of the Republic of Uganda, that the right to fair hearing includes the right to a speedy hearing, and that to require the defense to make a formal application would be to inordinately delay the trial and infringe on that non-derogable constitutionally guaranteed right. The right to a fair trial is not only a right of the accused, it's also a right of the prosecution as the representative of the public. A fair trial is one which satisfies the public interest in getting at the truth while preserving basic procedural fairness to the accused. In Constitutional Petition number 17 of 2024, determined on 2nd June 2026, and it is Farouk Mohammed and others versus the Attorney General, it was stated that, among others, that in interpreting Article 28 of the Constitution, it is necessary to appreciate that the right to a fair hearing is not confined solely to accused persons. Article 28(1) expressly guarantees a fair hearing to a person and not merely to an accused person, as has been stated before. That the choice of language is deliberate, it reflects the framer's intention that the entitlement to a fair hearing extends to all persons whose rights or interests are affected by the outcome of a criminal charge. This necessarily includes victims of crime whose participation and protection are integral to the administration of justice. When this understanding is read together with Article 44C, which renders the right to fair hearing non-derogable, the constitutional position becomes even clearer. The right is elevated to a status that cannot be suspended, limited, or taken away under any circumstances. Its protection applies notwithstanding any other provisions of the Constitution, including Article 43, which ordinarily permits the limitation of rights in the public interest. The combined effect of Articles 28 and 44 is therefore that the right to a fair hearing is both inclusive in its scope and absolute in its protection. That's where that quote ends, that constitutional protection. In this case, the trial is at an advanced stage. 2 key witnesses have testified. The defense seeks to apply orally for leave of court to call and disclose defense witnesses and evidence. The Judicature of Criminal Procedure Application Rules provide that applications to the High Court shall usually be in writing. My interpretation of this is that it is only in exceptional circumstances where applications before the High Court may be made oral. I take this from the word shall usually be in writing. This provision gives this court discretion to determine whether an application for leave of court to disclose additional witnesses and evidence at this stage of the trial shall be oral or in writing. Considering that defense has already called 2 key witnesses, DW1 and DW2, an expert witness, is currently undergoing re-examination. Considering also that this trial commenced in June 2024, there should be an explanation of why since that time the witnesses who have all along had crucial evidence are only just surfacing. In the interest of balancing the rights of the accused and the prosecution of fair hearing, justification must be provided for the prayer to disclose new witnesses and evidence at this stage. This can best be done in writing. Therefore, the appropriate mode in this case is for the defense to make a written application supported by an affidavit stating the reasons for disclosure of the witness and evidence at this advanced stage of the trial. I find merit in the objection for this application of this nature to be made orally, and I make the following orders. The defense shall make a written application and disclose all their remaining witnesses and documents intended to be adduced by 19th June 2026. The prosecution shall file a reply by 26th June 2026. A rejoinder, if any, is to be filed by 3rd July 2026. The ruling in this application will be delivered on 10th July 2026. In the meantime, in the interests of speeding the trial, the defense will continue with their appointments.
We shall not be making oral submissions in that application. Your schedule doesn't include submissions.
For application and submission.
Unwritten.
Look at time.
Okay.
Yeah, all submissions and the application
With the application.
and written submission. Okay. The application and when the prosecution response, they will also put submission.
I wrote, did I also hear that we, on the application, we attach the evidence we intend to disclose?
No.
Because that's my road to quarter. Because we would have disclosed. We would have disclosed. Now what if she didn't do it? We can't disclose. We can't disclose. Do you understand? If she can determine that, we can't disclose, but we have already disclosed. Because are they inviting them to attack the evidence?
It's about the reasons for the applications. Yes.
She said so in the reading. You wait and hear. When you file the application, attach the evidence.
Means disclose it.
Disclose it. So why should I do my evidence? I have really evidence.
The defense shall make a written application for you to disclose all their remaining witnesses and documents intended to be adduced.
Including this.
And the document.
So do we attach the documents?
That's what it is.
Because that one, then we would have disclosed before the application is granted.
So the defense shall make a written application for you to disclose all their remaining documents and an affidavit. Sorry, I meant to say and an affidavit.
Yes. Is that?
In support of the application.
Yes.
So the affidavit have those.
No.
And an affidavit in
In support, yeah. It can't have the evidence because then it means you have disclosed before the application is granted.
An affidavit.
Yes. We want to disclose.
By June 19, 2026. Then the prosecution will respond by the 6th. Joined up by 3rd July, and then a ruling will be made on 10th July. Then new dates will be given.
But we can continue in the meantime.
But just for timekeeping, housekeeping, I'm only available up to 1 p.m. on that and unforeseen engagement at court.
By 11. Doctor, I didn't need to take the oath again, my lord.
I just remind you that
Yeah, right. Doctor, when we last appeared yesterday, you had told her lordship that you were engaged by KAA advocates in your capacity as a retired forensic pathologist. You remember that?
That's right, my lord.
Now, is it in that capacity that you made the reports in Exhibit 1 P128, D28, and D29?
That's right, my lord.
you what?
P128, D28, and D29, my lord.
I beg your pardon, my lord.
PE128, D28, and D29.
Yes. You recall, Dr. Njivwa, my learned friend put it to you that when you carried out the review and the report, particularly the disclosure of your review of the postmortem report of the late Katanga, he says that that was a crime, since according to him, he violated the Health Service Commission Act. Do you recall that?
Yes, my lord, I recall that.
Now, doctor, as a retired consultant forensic pathologist, are you bound by the Health Service Commission Act?
No, my lord, I am not bound by it.
My lord, can I have P128, D22, D28, and D29? 128, my lord. D22, D28, and D29. Now, doctor, in cross-examination, my learned friend repeatedly asserted to you.
Those assertions were totally untrue, without foundation, and an insult to me, my lord.
Can you look at exhibit P128? You have it?
That's right, my lord.
Right. When is it dated?
This opinion was dated 3rd July 2024.
And could you tell the court on what source document you relied on to make that report?
I relied on the post-mortem report that was availed to me, and the photographs also.
Right. Now, in your report, you made conclusions which, according to the prosecution in their cross, indicated that you could not have made that report without looking at the photos of late Katanga. You are referred in particular to paragraph 7. What do you mention in paragraph 7?
My lord, in paragraph 7 I said, should the exit wound have been through the right ear, then brain matter and bone fragments would have been evident through the wound, but these were significantly absent in the pictures, and more importantly, not mentioned in the post-mortem report.
Right. Now, can you clarify to our lordship whether you had looked at the photos when you came up with this.
Yes, my lord. I had looked at the photographs as I have mentioned in the opening of the report, that I base my observations and opinions on the post-mortem report as well as the photographs that were available to me.
And which photographs did you look at which you noted that the fragments and bone matter were absent?
Especially they were the post-mortem photographs taken at post-mortem,
Right.
where there was one wound marked A and another marked B.
And for clarity, where had you got those photographs from?
They were provided to me by KAA.
My Lord, can we have Exhibit 23, D23? D23, 1 to 14,
The what? Sorry?
D23. Doctor, are those the photos that you looked at for making?
Yes, my lord.
conclusions?
These were the photographs that were given to me.
Can you confirm to Her Lordship that bone fragments and brain matter were absent in the right ear as from those photographs?
Yeah, that's right, my lord.
Thank you. Now, you told Her Lordship that you received soft copies of the postmortem photographs on 9th October. You remember that?
That's right, my lord.
Can you clarify whether you had the soft copies at the time you made the conclusion?
No, my lord, I did not have soft copies.
Now, doctor, you did not have the soft copies. You only had the photos in Exhibit D23, right?
That's right, my lord.
Would you like to clarify to court how were you able to come up with the conclusions you made?
Yes, my lord. I looked at these photos, especially the right ear, and also looked at the post-mortem report. My basis was the photographs provided, and the post-mortem report.
And at the time you made the first report, is there any other information or document you did not have?
I did
the
not.
time of making that first report?
Yes, I did not have the witness statements and other evidence like the crime scene report that the DPP had disclosed at the start of the trial.
Right. Now, Doctor, when you received the soft copies of the colored photographs, did you say that was in October?
No, I received them in October.
Okay. Now, when you received the soft copies, did they in any way contradict the conclusions you had made by looking at the hard copies?
My Lord, they did not contradict.
Now, would you now want to explain to this court why was it necessary for you to make the second and the third report, the exhibit D28 and the D29?
My Lord, when I made the report of 3rd July 2024, I had a number of queries.
Beg your pardon, my lord.
When you made the report of 3rd July 2024, we had a number of queries.
One of them was whether the deceased was right-handed or not. 2, whether the deceased had any neurological or physical impairments that could have prevented him from shooting himself. Whether fingerprints were lifted from the trigger of the gun. The behavior of the
My
deceased.
lord, can this not be down?
Yeah.
Doctor, I'm typing.
Oh, okay. I'm sorry.
This is what he
My
was,
lord,
this is what he was doing.
I lost him.
So whether fingerprints were lifted from the trigger of the gun.
My lord, we lost him at whether the deceased had any
Physical or neurological
Impairments.
impairment that could have
prevented
prevented
him
him
from
from
shooting.
Shooting himself.
yes.
Whether fingerprints were lifted from the trigger of the gun.
And the behavior of the deceased prior to his death.
Very well.
So these were this, my lord, this was the information I needed to support my observations right from 1 to 12.
Is that anywhere in your first report?
No, I did not expressly put it like that, but I raised these questions in the report.
Okay.
Yeah.
Which one?
The first report.
The first report.
Yeah.
That is D. Okay. Can you read what you put down in that? Yes.
The whole report, or just that part? Okay. My lord, this is what?
The part which relates to what you have told her lordship.
Yeah. Okay. What I wrote is this. If the gun,
No, can you maybe, for the sake of time, go to the page 3?
that's right. That's what I am.
Yes.
That's what I'm reading.
The last paragraph?
Yes, the last paragraph. Okay.
You can read it.
My observation was the gunshot injury was to the head, an elective and the most common part of the body targeted in suicide cases.
Yes.
The gunshot was also a close contact, considering the blackening of the right ear. If the gun that caused the injury was found at the scene, and the deceased was right-handed, then these features are highly consistent with a suicidal gunshot injury. Further, it should be established if the deceased was right-handed, as it has further been established that most people use the dominant hand to commit suicide when they shoot themselves. It is also important to establish if the deceased had any physical or neurological impairments that could have prevented him from shooting himself. If fingerprints were lifted from the trigger of the gun found at the scene, this would be helpful in proving this as a case of suicide. The behavior of the deceased prior to his death should be investigated to establish if he had a mental disorder which could be associated with suicidal ideation.
Right. So these are some of the other information that you required to come up with the rest of the reports.
That's right, my lord.
Thank you. Now, you recall, Doctor, a learned friend put to you that you made report exhibit D28 and D29 after this court had made a ruling of no case to answer, and that the reports which you made were calculated to advance the defense theory of the accused. Now, do you know when this court delivered the ruling on no case to answer?
No, my lord, I don't know.
Have you ever read that ruling?
No, I have not read that ruling.
In the two exhibits, D28 and D29, did you make any reference to the ruling on no case to answer?
No, my lord, I made no reference to that.
Now, Doctor, what do you then have to say about this assertion and allegation from the prosecution that you made the two reports after looking at the ruling of no case to answer to advance the defense theory?
That's totally in the imagination. My lord, the foundation of exhibit here, DEX 28, is on the report that I made on 3rd July. I see no contradictions in the two reports. One is simply, the second one has filled in the gaps that were in the first report. My lord, I am not sure if by 3rd July 2024, whether it had been said the accused had a case to answer, I don't know.
Thank you. What about the third report?
My lord, the third report was simply a PowerPoint presentation I made so that people who are lay in the medical field could understand the scientific basis of my observations. I made this to make it very simple, in my opinion, to make it simple for lay people in the medical field, like lawyers, to understand.
We are grateful, Doctor. Now, Doctor, did anyone, be it Mr. Elson Karuhanga or anybody from the firm of Kampala Associated, the accused persons, or any person, direct or influence your findings and conclusions in the reports which you made?
Absolutely not. My Lord, these are technical reports. I don't know where the advocates of KAA even had the brains to make such a presentation.
Now,
They have no brains.
medical.
Make the report.
Medical. Doctor, you told this court that you interacted with Mr. Karuhanga of KAA more than 10 times during the preparation of your reports, right? Do you recall that?
That's right, my Lord.
Would you like to tell the court the purpose of those interactions?
My Lord, Counsel Karuhanga, it took me 3 meetings with him to understand the concept of beveling. A lot of the technical issues here
Mr. Morgan is not understood.
He will not understand. He will not understand up to the end of the trial.
Up to now.
An average person.
my Lord, just to explain an abrasion ring
3 meetings.
took me 2 hours to explain to Counsel Karuhanga. So it was really basically to take him through the ABCs of gunshot injuries and then my interpretations of this.
Was it to explain?
Yeah. Explain basics of gunshot injuries and then their relationship to the injuries that the deceased sustained.
Okay. Right. Doctor, my learned friend asked you to read paragraph 8 of exhibit P128, the first report. You have it?
Yeah.
Yeah. He asked you to read paragraph 8 as well as the last paragraph. And the insinuation by counsel was that those 2 paragraphs were contradicting each other on the issue of the direction of the bullet. Can you now make clarification on the 2 and whether they actually contradict each other?
My Lord, in paragraph 8, I noted this. There is no independent forensic evidence described or otherwise to confirm that the wound on the left temporal area is the entry wound. The descriptions stated in the post-mortem report of these wounds. And these descriptions are no blackening, no tattooing, and no muzzle imprint are in fact consistent with descriptions of an exit wound. My Lord, in chapter 10, paragraph 10,
Yes.
a bullet path is traced by the correct identification of the bullet entry and exit wounds. In this case, the erroneous identification of the entry wound led to a false identification of the direction of the path of the bullet.
Right. So, Doctor, and whether those duties apply to medical health practitioners, then he told you actually, but you denied that you exhibited cognitive bias in your report. He further put it to you that since cognitive bias is a mental element, it is evidence from the circumstances surrounding your report, right? Doctor, would you like to clarify to his lordship whether indeed there was any cognitive bias
My Lord,
in the report and in the entire execution of your duties?
my report, to the best of my knowledge, to the best of my abilities, is very objective.
Prosecution also put to you that you did not apply reliable and applicable principle standards in the report. Doctor, are you aware of any applicable scientific principles that you disregarded in the execution of your reviewed report?
None, my Lord, none at all.
My learned friend also put it to you that in your report, you make no mention of any limitations, alternative theories, knowledge boundaries, and uncertainties. Now, would you like to explain to this court what those limitations and alternative theories would mean in this circumstance?
My Lord, to me, the case was either a homicide or a suicide. In my report, For instance, the first report on page 3, I noted that these features are highly consistent with a suicidal injury. I did not say this is suicide. I say highly consistent.
Meaning,
Most likely a suicide case.
thank you.
The same, my lord.
My lord, can we read that?
Oh, okay.
Yes, my lord. At more likely, my lord.
Stop that. This means that most likely a suicide case. Then my Saturday new sentence was
Yeah.
the same.
Yeah. In defense exhibit 29, again my conclusion is that the possibility that this is a homicide is extremely slim and highly unlikely. And my lord, I also concluded, I said, the forensic evidence in this case points to suicide unless proven otherwise. My lord, to me, I'm exercising objectivity.
In Exhibit D22, you have it, the postmortem report.
Yes, my lord, I have it.
In that postmortem report done by Dr. Ambayo and Dr. Male Mutumba,
That's right, my lord.
did they make mention of any limitations and or any alternative theory?
I don't see that anywhere.
Right, doctor. The prosecution put it to you that you failed in your duty to remain neutral and objective and professional. Now here the insinuation was that you were expecting to be paid from Kampala Associated Advocates for your report and you giving testimony in this case. You also recall you told Her Lordship that you expect to be paid approximately 10 million from Kampala Associated Advocates for your services, of course. Now, you also mentioned that in the Rweza case in Fort Portal, you filed a bill, right? Now the question is it unprofessional, unethical to receive payment in respect of professional consultancy services?
To the best of my knowledge, it is not unethical to be paid for professional services. My Lord, there's something called professional fee that I'm aware of. So,
Are you aware of any legislation which bars you from receiving professional fees for your services, or for any other professional in that matter?
no, my Lord. My Lord, I've even been engaged by government and paid a professional fee after my retirement.
Is your payment conditioned on the accused, in this case, being acquitted?
No, my Lord, there's no such thing.
Doctor, did the expectation for payment for your services influence or compromise the independence and opinion which you expressed in your report?
No, my Lord, it did not.
Now, you recall, Doctor, that one of the duties of a forensic scientist, as put to you by my learned friend here, was the duty to consider exculpatory evidence, to which you agreed. Yes? Recall that? Exculpatory evidence is the one which tends to clear someone from the charge,
Oh,
right?
yeah.
Now, in this case, was there an exculpatory evidence for you to consider from
No.
all the material that was disclosed to you?
No, my Lord. My focus was basically one. Were my findings consistent with suicide or with the homicide? There was nothing to bias me. There was no evidence to sway me, to unduly influence me, my Lord.
Doctor, you told her lordship that you received a copy of the DNA report. You recall?
That's right, my Lord.
You also looked at the blood splatter pattern analysis
That's right, my Lord.
and also the SOCO report.
That's right, my Lord.
My Lord, can we have them for him to look at? Yes. Yes. return to them later, my lord. Let him still have them. Put them on the side. Doctor, which is the first one which you are looking at?
Crime scene report on blood stain pattern analysis.
Okay. When was it made? What date?
25th January 2024.
Right. And the next one? What is that?
This one was done on 30th April 2024.
Right. That is the DNA report?
DNA analysis report.
Okay. And the last one?
The crime scene examination report dated 2nd January 2024.
Right. Now, doctor, can you confirm that those three reports were issued long after the postmortem report by Dr. Ambayo and Malay?
That's right, my lord.
Okay. In your report, did you consider those three reports in your review?
Yes, I did.
Right. Right. Doctor, you recall, my learned friend spent a lot of time on the gunshot wounds, right? Their characteristics and direction of the bullet. Right? The prosecution suggested to you that the bullet that killed the late Henry Katanga moved from left to right, and that the wound on the left temporal area was the entry wound, while the wound on the right ear was the exit. You recall that?
That's right, my lord.
Now, in all your three opinions, and throughout the cross-examination, sorry. I want to take you back a little. That from the prosecution, the bullet that killed the deceased moved from the left to the right, downwards through the exit in the right ear. Right? In the three reports which you made, you maintain from your reports and from the cross-examination that the findings which you made in the report D22 by Dr. Ambayo and Male are erroneous, and that the bullet moved from the right to the left. Right?
That's right, my lord.
Now, first of all, Doctor, my lord, can we have A and B on the screen? As you go to the images, what are the characteristics of a gunshot entry wound?
My lord, the key characteristic of a gunshot entry wound is a collar of abrasion.
My lord, I thought we traversed that extensively, some evidence in chief and in cross-examination. In the re-exam, counsel should be asking any clarification that was not clear, as opposed to asking a witness to repeat what he already put on record in respect of the characteristics. We would be doing much more than what is expected in the process of re-exam.
Sorry.
It came up in the cross-examination.
Yes, indeed, my lord, and I have all the right to. Much obliged, my lord. Yes, doctor, proceed.
The characteristics of a gunshot entry wound will depend on the distance from which the firearm was held.
Let's go to
But
the
yes.
near contact.
Yeah.
Okay, fine.
Yeah. My lord, it has been universally accepted that gunshot entry wounds should have a collar of abrasion. A collar of abrasion, a ring of abrasion. Yeah.
That is from a distance or?
Yeah, no, even if it is close.
Okay,
Yeah.
okay.
That's when the bullet spins and burrows into the skin. It will leave an abrasion ring at the entry.
Yes.
Now, in addition to the abrasion ring, there may be muzzle imprint, soot deposition, tattooing, burning effect of the flame, and in addition, the edges of the wound are inverted.
Right.
They go inwards. Inverted means it goes inwards.
Yes. Now, look at exhibit D22 and P4, my lord. P4.
Yeah, yeah.
You have?
Yes.
Okay. Fine. That is the report by doctors who?
Ambayo and Male.
Ambayo
And Male Mutumba.
and Male Mutumba. In their findings on the entry wound, did they find those characteristics?
That is hearsay evidence. Even in cross-examination, we never asked him to tell us what those two doctors found. My Lord, there is nowhere where I crossed to ask him to tell us what the other colleagues found. Never rose.
My Lord, my learned colleague extensively cross-examined on inverted edges. He put it to the witness that they were inverted edges. And the witness has just told us 6 characteristics of an entry wound, and one of them is inverted edges. And my learned brother, Mr. Kabega, is going to that, is asking the witness to look at the post-mortem report, because they described the wounds, and then see if they described one of those characteristics, or if they described all of the characteristics. So, my Lord, it is in order. Inverted, everted appeared here from the bar, from the cross-examination. So can we find those terms that he was using and putting the witness in the report or outside the report is where my colleague is going. So I think, my Lord, it is in order.
There was cross-examination on characteristics of your gunshot entry wounds.
Yes.
And those pictures came up several times in cross-examination.
Yes.
The witness was asked in cross-examination and in examination.
My Lord, you have made a ruling on this matter. Council cannot disagree.
Counsel, you can't mislead the court.
Let me check the report.
You can't mislead.
No, I'm not misleading the court.
What came up in relation to that report and
Post-mortem report by doctor.
Was in respect to his comment that they never mentioned the word beveling in their report. And the question was, because it was not mentioned, is that why you assume that they never considered the beveling defect? And he said yes. So, when it comes to characteristics of exit and entry wounds, our emphasis was only in respect to the 2 photos, and we never made comparison with the postmortem. It would be most of that, my Lord, if we go back to the report.
I quite recall a comparison between his 1-page report
And
and
5-page.
That is in
5-page report, and then asking
Yes, that was
That
in respect to whether
the form,
it was
not
detailed.
content.
Because that was in form, rather not content.
Because it has no content.
We wouldn't have asked him to solicit hearsay.
What he has said.
find what the context in which the
Because Mr. Kawega is asking him to mention whether the doctors said so.
Whether it is written there. Hey.
And my Lord, the practice of overruling court is not healthy. Let's move.
They are now realizing.
You have ruled. You have ruled, my Lord.
Mr. Kuwela,
Yes, my Lord.
let us find out whether indeed they traversed it.
Yeah, my Lord, you have pointed out 3 incidences, and you are right.
Let me check.
And you are right.
Just for purposes of ensuring that the report. But that is what I know. Let me check.
Who made that report?
The post-mortem report was made by doctors Male Mutumba and Ambayo Richard.
Thank you. What are the characteristics of an entry gunshot wound disclose range as recorded in the report.
My Lord, the wound on the left that my colleagues described, they said it is starlet shaped. Starlet shaped. And then
Starlet meaning star shape?
star shaped.
Yes.
My Lord, we went through council with council here, and actually starlet wounds were exit wounds.
Still answering the question.
Yes, it's okay. No, okay, yeah. But here it said it is starlet shaped. He say it has. There was no blackening of the tissues around the entry wound, and also no tattooing, and no muzzle imprint.
Right.
No mention was made of the edges.
Now, doctor, if those characteristics are not present, can you term that as the entry wound?
You can't, my Lord. You can't. They say no blackening, no tattooing, no muzzle imprint. Then they say star-shaped. No mention of edges. You cannot call this an entry wound.
Thank you. So, would I be right to say that a wound with the characteristics you have mentioned cannot be classified as an entry gunshot wound?
That's right, my Lord.
Right. Now, looking at that photo, doctor, do you want to clarify to court in relation to the edges of this wound?
Yes, my Lord. Clearly, that wound has been shaved. The area around it has been shaved. Normally, the wound is shaved so that you can demonstrate the nature of the edges. My colleagues shaved this wound and then refused to comment on the edges. Number two, there is an unexplained white strand in that picture. Number three, there's an unexplained white strand in that wound. Yeah.
Yeah.
Are we using A or B? My
Lord, we need to be clear for purposes of submission. Let's be consistent. We need
Go to the one
submit.
where there is a ruler. Next. Go on.
My Lord, do you remember us cross-examining based on the one with the ruler?
You asked about ages.
Yeah, but my Lord, re-examination is limited on specific components that
Go
were
on.
traversed in cross-exam. We shall be, my Lord, confusing the court record. We had a choice to cross-examine A and B. So we cannot now re-examine on other photos, my Lord.
There's an unexplained white stripe.
On photo A. My Lord, there.
Okay.
Show it to us.
On that wound.
Most of blood. Most of blood.
Show it to us.
Okay, let him zoom.
Go down.
Hey,
On A. A.
let him zoom it. Yeah. No problem.
But it is again the one with the ruler. Why are we having
Yeah, yeah. That
Can you
one.
zoom that?
Yes.
Yes. Mhm. Give it to doctor so that he can
Show us.
place the cursor. Yes.
clear in the one with the ruler?
Which one, my Lord?
Where the arrow is. Yes.
It is unexplained.
Yes.
It's unexplained, yes. My lord,
Now go to the...
here.
Yes.
Yes, that's quite fun. It's unexplained.
Maybe.
Unexplained by who?
Yes.
By
And my lord,
By him or those who
and father, there was a bone defect behind this bone. There's a bone defect where the bullet passed through. So in the process of shaving this wound, you definitely interfere with the edges. And that's why counsel here, during cross-examination, told me that even his grandmother knows that those edges are going inwards. So, to me, it is wrong to assume that the edges are inverted.
Does the postmortem doctor, sorry, does the excuse me, does the postmortem indicate that the edges in that what they call entry wound is inverted?
No, no mention is made at all, my lord.
By
No mention is made by the authors of this postmortem report,
Dr. Ambayo and
Dr. Male.
yes. And had this wound been inverted, do they have recorded it?
My Lord, let's be fair, my Lord. So, Mr. Kabeka wants this
My Lord,
witness
let-
to
let
enter
me-
into the mind of the colleagues.
Let me proceed. Let me proceed. Sit.
And with the drawing.
You sit. Doctor, the nature of a wound which, if inverted, is a matter the doctor carrying out postmortem would have listed.
That's right, my lord.
Now, is there, therefore, any scientific basis for one to have classified this as an entry wound?
Absolutely none, my lord.
Sorry, my lord.
You
Basis for one to have classified that as an entry wound.
Can we now go to the next photo? B. Doctor, you, in cross-examination, gave the characteristics of a near-contact gunshot entry wound. Yes?
That's right, my lord.
Are the characteristics of a near-contact gunshot wound expressed in this photograph?
That's right, my lord.
For clarity purpose, can you point them out, Our Lordship?
My lord, the main characteristics here are: one, the powder blackening. The second one is the blast effect of the gases which have caused extensive tears of this ear, multiple lacerations. And my lord, I would like to make it categorically clear that the force which caused these lacerations must have come from outside to inside. It could not have been from the other side.
Inside, outside.
It could not have been from inside to outside. Otherwise, it would have blown off this whole ear. It is from outside to inside. And my lord, our ears, common sense, they are like this. Huh? They are not folded like this. They are not folded like this. Our ears are open. So to have caused that injury to the, and it is on the outside of the ear, outer aspect, the force could only have come from outside inwards. So these characteristics of the blast effect and the blackening are what makes it a near contact wound, my lord.
Yeah. Right. Doctor, from the report made by Dr. Mbaya and Malay, in their post-mortem report, they classified this as the exit. They say it was 5 centimeters by 3. And you recall it was your evidence in Ross that the entire evidence, the entire dimension of the right ear were taken and stated to be the dimension of the exit wound. You call that?
That's right, my lord.
That was his evidence in chief. I never cross-examined him on the so-called dimensions. So what Mr. Kabega is recalling is their own evidence in chief, which we chose deliberately, we ignore.
Non-reason.
Because
No, don't testify.
we could not cross-examine on anything.
Don't testify.
We only cross-examine.
We're not objecting to his testimony or his
we
reasons.
only cross-examine on what was worth that time.
No, actually, because one of what was really worthless. But
May I proceed, my lord?
I never went to their measurements.
But
Never went to the measurements, or do we check that?
We never went to the measurements.
let's find out from the witness, my lord.
It's not him who was.
He's here.
I was very deliberate about it.
Yeah.
Doctor, was that measurement by them correct?
No. Yeah.
Can Mr. Kabega take court to where I ever asked any question on measurements? I never did. And deliberately so.
Okay, now, I want to move on, my lord. Yeah, because they are trying to distract me. But I'll move on. In Exhibit D28, you stated in the cross-examination that there is no forensic evidence to support the direction of the bullet, as you stated in Exhibit D22. Can you now summarize to court, right, doctor, the forensic evidence which supports the direction of the movement of the bullet?
My lord, the wound on the right ear, as I mentioned, have the characteristics of the entry wound. The wound on the left, above the left ear, have the characteristics of the exit wound. Based on these two, the direction of movement of the bullet was from right to left and upwards.
Right. You recall, Doctor, my learned friend challenged the near contact range findings because, according to them, in that report D22, no soot deposit, no tattooing, and no binding on the left temporal wound. Then counsel suggested to you that soot could be washed away by washing the body or by blood, to which you kind of agreed, right? Now, in all the documents which you received from Kampala Associated, the evidence, did you come across any evidence to suggest that the body of late Henry had been washed before being taken for postmortem?
No, my lord.
You indicated a short while ago, photograph A, that there was shaving around the wound, right?
That's right, my lord.
Did the two doctors make note of that in their report?
No, they did not.
Did the two doctors in their postmortem report indicate any limitations that would have hindered them from observing, for example, the tattooing, the soot deposit, muzzle imprint?
No, my lord, they did not.
Now, again in your testimony and cross-examination, you stated that bone beveling is the gold standard for determining bullet entry and exit points in gunshot wounds to the skull. Yes?
That's right, my lord.
It is also your evidence that in that postmortem report D22 and P4 make no mention of beveling at all.
That's
Yes?
right, my lord.
So does the absence of beveling from the report mean that there was no beveling on the skull of the deceased?
Of course, it does not mean there was no beveling. It only means it was not looked for and documented.
Thank you. And doctor, in a case involving a dispute in respect of gunshot wound to the head, what would the failure of a pathologist to document bone beveling tell you about that examination?
That it was poorly done.
Doctor, again in cross-examination, you are asked whether you could conclusively determine entry and exit without relying on bone beveling, and you said yes. But, doctor, in absence of documented beveling, what other features could you use to rely upon to conclude that the wound on the right ear was the entry wound and the one on the left being the exit wound?
The soot deposition, which is on the right ear, and the blast effects of the gases.
And doctor, you recall in a cross-examination by my learned friend, in reference to this photo, B, my learned friend insinuated that what you call soot is actually a shadow and a cloth. What do you say to that?
Yeah, my lord, a shadow is an outline of one object that stands in front of a source of light. In other words, a shadow has an owner. I don't see that blackening having any owner anywhere. And my lord, what is a shadow is clearly there. The shadow of the ear behind it. You can see this black area behind the ear. This, the outline of the ear. Yeah.
First, point out the blackening from the soot.
Yes. My lord, this is the blackening of the soot. Now this here is the shadow of the ear. This is the real shadow of the ear. But that one has no owner. That's the blackening. But the real shadow is here. You can see there is a shadow here of the ear. Number two, this cannot be a clot because my friends documented clots in their report. Where there were clots, they documented. They never documented any clot on the right ear.
Can you, doctor, from the postmortem report show whether the clots were documented.
My Lord, on page 2, at the beginning of page 2, it is clearly documented there was clotted blood over the face, left shoulder, anterior aspects, right shoulder, and arm. This were what was documented, my Lord.
Doctor, in cross-examination on Exhibit D22, postmortem report, you did not, it is your evidence that you did not find anything to show that the hands of late Henry Katanga had been swabbed for gunshot residue, right?
At post-mortem,
Yes.
yeah, it was never mentioned, my Lord.
What would be the forensic significance of a failure to take gunshot residue swab from the deceased's hands?
My mic is not working. Huh? My Lord, if it has been specifically mentioned in police form 48 that this was a case of suicide, then it is absolutely wrong not to swab the hand for gunshot residues. My Lord, it is better you try and fail rather than fail to try.
To you, put it to you, the prosecution put it to you that you violated the sub judice rule because you posted or shared your reports in this matter with PowerPoint presentation with the on a Uganda platform on 13th May 2026. Right?
That's right, my Lord.
Did you share your reports on that platform?
Yes, I did share my report on a closed group of 72 pathologists in Uganda. 72 pathologists.
Is that platform open to the general public?
No, it is not, my lord.
And anyone who is not a pathologist join it?
No, my lord, it is only for pathologists.
Right. You also recall, Doctor, that questions were put to you suggesting maybe before I go, why did you post your report on the group?
My lord, after court here, I found a lively discussion on the court proceedings that day on that platform. I made a posting of the 50 slides so that the pathologists who were discussing already could discuss from an informed point. Number two, these presentations were already out. They were already, I am sure, even what I am talking now is being watched on YouTube. So I was not posting anything new on that forum. So, and of course, it generated a further debate. To me, it was like, I have now made this presentation. What do my peers say about my scientific presentation?
In effect, they were kind of peer reviewing what you had done. Much obliged, my lord.
I wrote this. Mr. Kabek is making the witness to offend further the rule. He's being unfair to the witness. The damage is already done. You are cementing.
You can.
Questions were put to you. Questions were put to you, Doctor, comparing your retirement status with that of Dr. Male Mutumba. And from your understanding of the material you reviewed, what was...
My lord, did we ever ask that? I never asked about retirement status of the witness vis-a-vis any other person.
Okay.
That's the new matter being introduced.
Okay.
That's the new matter.
Very well.
His own, not for others.
Right, okay. Doctor, questions were put to you during, of course, cross-examination, and were being referred to as the grandmother test. Recall that? In relation to the wound on the left side. Oh, sorry. Thank you. Questions were put to you concerning what you refer to as the grandmother test in relation to the wound on the left of the deceased side, head. Would you, doctor, explain to court what you mean by inversion in that context?
My Lord, counsel suggested that we should bring his grandmother to come and look at these wounds, and it would be obvious that the wound had inverted edges. My Lord, for us in pathology, we leave our grandmothers and fathers in the village. We do not bring them to practice pathology in court. Yeah. Wherever they are, those grandmothers, we let them retire in peace. Their eyesight is even compromised.
Right. And the doctor, is inversion alone sufficient for you to determine whether the wound is entry or exit?
No, it is not. It cannot.
Again, my learned friend put to you, suggesting that the wound on the left side of the head of the deceased would represent an intermediate range or distant range entry wound. Doctor, what is your comment on that?
My Lord, the wound on the left should never be looked in isolation of the wound on the right. When the wound on the right clearly bears features of the entry wound, it is useless to start speculating about the wound on the left.
Doctor, I recall maybe, doctor, supposing you looked at it alone, that wound, would you still agree or disagree with what the prosecution had put to you? That is intermediate?
My Lord, if that wound had been alone, now, in absence of a ring of abrasion, it cannot be an entry wound.
Now, you recall my learned friend submitted or gave to you the judgment of the case which was in Fort Portal, right? Do you recall?
That's right, my lord.
Yarmanga.
That's right, my lord.
And he stated that you ignored the girl report. And if you had not, would you have come to the same conclusion? Can you shed some light on that, Doctor?
Yes, my lord. I recall that case. My comments are this. One, I did not ignore the girl report. It was part of my report. Number two, I called it an anesthetic death. And somebody who does not know what an anesthetic death is would think that because excessive anesthesia was not found in the deceased, somebody who does not know what an anesthetic death is would think that because an overdose of anesthesia was not found in the deceased, then this could not be an anesthetic death. My lord, that is erroneous. An anesthetic death is any death associated with the process of anesthesia. And in this particular case, the young man had eaten his breakfast. He had simply come to ask if the surgery would take place the following day, as had been scheduled. The doctors told him, we have space today to do this surgery. And in the process of the surgery, they made him sleep. And he vomited the stomach contents. Those are the ones which went into his lungs and killed him. So the patient was not prepared for surgery and was given the wrong anesthesia. So this is really the story of what happened in Fort Portal.
Right.
My lord, I examined these tissues under the microscope and saw the damage in the lungs that were caused.
Right.
And so, because I had established 100% what the cause of death was, I made my report very confidently, my lord.
Doctor, you recall, my learned friend also suggested to you that you engaged in a corrupt practice when you issued to the relatives of the deceased a receipt demanding payment of 1.8 million shillings from Makerere University.
On government receipt.
Can you shed light on that, Doctor?
Yes, my lord. I gave that receipt in respect to this same case. The payment, my lord, was for the post-mortem examination, for analysis of tissues.
My lord, by same case, he means this one under trial?
Yes,
Yeah,
yes,
Ruhanga.
yes, it is this same case.
Yes.
Yes, it's the same one, my lord.
I'm sorry, my lord.
Yeah, Ruhanga. Photo. Is this the Ruhanga?
And my lord, my facilitation and stay in Fort Portal during the trial. Fortunately, my lord, the lawyers for the diocese wrote to Makerere University, and we discussed this issue with the principal and the dean in medical school. And they said I had done the right thing. This case, Makerere has never complained. I have never been taken to court.
You wait.
Maybe council will start that one now. But
That's why I'm advising you not
Yeah.
to be excited about.
so that is, my lord, that is the story.
Okay,
Yeah.
fine. Now, Doctor,
I'm returning the treatment.
That's why he was standing, my lord.
Yes, my lord. Don't run away from my state. I will stand with my people.
Doctor, in your cross-examination, we come across City Mortuary, KCCA Mortuary, Department of Pathology, and Department of Pathology, Makerere University College of Health Sciences, right?
That's right, my lord.
Would you, for this court, shed light on each of these?
My lord, under Makerere University, there is the College of Health Sciences. And under the College of Health Sciences, there is the Department of Pathology. That teaches medical students, postgraduates, and even people doing PhD. One of the subjects taught in the Department of Pathology is forensic medicine. And this subject is practically taught in the Kampala capital city mortuary. My lord, it's the pathologists from the Department of Pathology and the postgraduate students in that department who for a long time have been carrying out postmortems in that department, in the mortuary. The mortuary belongs to Kampala City Council Authority. And so we've had a very good relationship until the police threw us out. Not only me, as council suggested, sour graping, the whole entire team of us, senior pathologists, were thrown out of that mortuary. And so we could not supervise the upcoming or the people who were deployed there. And my Lord, the place is now being manned by police officers who are doctors. And this is very dangerous. You can see in this case, my Lord, the police officers, the CID officers, went to the scene and determined the entry and exit wounds.
Is he still answering
Yes.
a question related to anything that arose in cross-exam? Or is opening a new area for which we may need, my Lord, extra time to further cross-examine him?
Oh, okay. Okay. Yeah. I was asking about the relationship between yeah. Okay.
Incidentally,
Okay.
is Dr. Ambayo,
My Lord, that is the real
police officer.
of this.
That's right, my Lord. Yeah? No, it's okay. Uh-huh.
Is Dr. Ambayo a police officer?
Yes, he is. He's a serving police officer.
Thank you. My learned friend here suggested to you that in fact you are sour graping because of having forced out of the KCCA mortuary. What do you say to that, Doctor?
That's not right. It's not only me, it's the whole entire team of senior pathologists who were forced out.
My learned friend took you to the case of Honorable Nevanda's death, recall?
That's right, my Lord.
And you said you were arrested.
That's right, my Lord.
Would you clarify to court the circumstances relating to that case and you being arrested? And what happened after your arrest?
Yeah. First, my Lord, this case was essentially of Nebanda. My arrest and prosecution in the Nebanda case was based on two things. Per diem, my Lord. It was per diem which caused this disaster. My colleague wanted to take these samples, the second set of samples, to London and asked me to request Parliament to facilitate him. when I told him,
My Lord, will that colleague be given fair hearing at this stage before this
yeah.
court? Does Mr. Kawega feel that is going in the right direction?
Yeah. Yeah. Oh.
My Lord, that doctor can only concentrate on
Oh, yeah.
issues of money.
Yeah. Okay. Yeah.
At least we traversed his love for money per year. Yes, but not other third parties.
Yeah, but my lord, he has not mentioned any names.
You can't do that.
He hasn't mentioned any names.
You're allowed to do that. He has
Yes.
not even mentioned any
He hasn't mentioned names. He was very careful.
Yeah.
Please.
And my lord, when I declined that request, I was betrayed. I was betrayed that I was not there in the post-mortem room when this post-mortem was being done. And it was said that I stole body parts which the police are the ones who gave to me. Ultimately, when the case went to court ruled that I had no case to answer. There were two of us. One of us has been appointed a minister. My lord, I'm waiting for my appointment.
Right. Yes, yeah. No, just two questions. I'm very alive, my lord, your time. Yeah. Yeah. Doctor. The prosecution took you to this book of yours, and specifically at page 32, where you specifically mention reasons for giving conflicting expert opinions. Right?
That's right.
And it was also suggested that that book of yours has never been peer reviewed. So, what would you say to that, Doctor?
My lord, that this book was not peer reviewed, I said this book has been reviewed by one of the world's leading forensic pathologists, Professor Michael Polanin, the chief forensic pathologist of Ontario in Canada. My lord, the foreword to this book was written by Honorable Justice Dr. Henry Peter Adonyo. he could not have written this without reviewing the book.
We review and then move forward.
So, as far as the review is concerned, this book has been widely reviewed. And my lord, regarding page 32, I simply wrote about why different experts may make different reports or different opinions about the same case. Yeah, so
Very well. Now, you also recall, Doctor, my learned friend took you through this book, Forensic Medicine, Medical Law and Ethics in East Africa, right?
that's right, my lord.
First of all, I want you to tell court whether it has a list of contributors, and if you appear there.
Yeah.
And also go to page 231.
Yes, my lord. This book, Forensic Medicine, Medicine Law and Ethics in East Africa, has a list of contributors. My lord, I am humbled to say that I'm one of the contributors to this book. It's a forensic book for East Africa.
To what page?
On page 6,
You are listed, are you?
I am listed as one of the contributors.
Right. And finally, can you go to page 231?
231, yes, my lord.
Look at that photograph which appears there.
My lord, can we be sure about
The same.
It's a picture, my lord. It's not a
Just
photograph.
turn the book like
Yeah,
this
yeah.
for him
Okay.
to see.
It's an illustration, my lord.
my lord?
What do you say about that picture, Doctor, in relation to gunshot?
My lord, when I was asked in cross-examination, these bones which were coming out on the opposite side of the gunshot, the prosecutor implied that these could be blast effects. My lord, this cannot be. Because blast effects are a result of the gases that come out. The gases cannot traverse the head and cause bones to shatter the other end. It cannot be blast effects. So blast effect is on the side where the gun is shot from. In our particular case, on the right side. So the blast,
B.
yes.
Thank you. My lord, that is all from me. Thank you.